Welcome to For Better or For Court, Family Law in New Jersey.
Hey everybody, welcome to an all-new episode of For Better or For Court, Family Law in New Jersey with Alix Claps. I'm your host, Mike Leon. Alex here is a partner over at Heyman and Fletcher Law and a certified matrimonial law attorney with years of experience guiding clients through divorce, custody, and complex family matters across the state of New Jersey. And in today's episode, Alex is going to explain whether or not custody or support orders can be changed later on in life. Because as you know, life doesn't stand still. I mean, jobs shift, there's kids that grow up, circumstances change. So it's important really to understand when and how the law allows for modifications. Alex, it's so good to see you. Let's get into this first question about, are custody and support orders subject to modification under New Jersey law, or are they just considered permanent?
Hi, Mike. Thanks for having me. As always, the answer is it depends. Custody orders are almost always subject to modification because the child's needs continue to change as the child gets older. The parents' needs can change relative to the child. So that is always subject to modification later on. Support orders are subject to change under certain conditions. Child support is always subject to change, largely for the same reasons that custody can change. Spousal support, what we call alimony, may or may not be able to be changed down the line. It depends on how you reached your initial settlement or judicial decision.
So what are some of the life changes I was just mentioning before about life changing? So what are some of these life changes that are significant enough for a judge to consider whether it be altering custody or parenting time?
If you're talking about sole legal custody versus joint legal custody, that's a change. There can be a significant circumstantial change involving one parent's availability. A parent gets incarcerated, a parent gets deported, a parent moves out of state, there are a number of ways where that can come into effect. Acts of domestic violence or abuse leading to a breakdown in the co-parenting relationship, making it impossible for the parents to coexist. Issues with addiction can lead to a change from joint legal to sole legal custody. Parenting, it's a lot less dramatic. Parenting time can change because a child goes from being in preschool to being in elementary school, or a child goes from being in elementary school to being in middle school and suddenly is playing travel soccer, and the schedule that was working just doesn't make sense for the child any longer. So it's not always a bad thing that happens that requires a change. Sometimes it's, hey, here's this new opportunity. We were doing a 2-2-3 schedule, but the child's now 14, wants to do a week on, week off, so there's less back and forth. Okay.
So on the flip side, on the child support side, what are some situations there where it might lead the court to kind of recalculate the child support obligations?
I think the most common change is that one or both parents is making more money, because there are a couple of things that go into child support calculations. Parents' income, the schedule. So sometimes if there's a big shift in the schedule, that can also trigger a recalculation. And health insurance premiums is the other kind of general big component of the child support. So a large financial change for a parent or a change in the schedule are the most common reasons why the support gets recalculated.
Alex, let me ask you, what evidence does the court consider, or what evidence do your clients potentially need to demonstrate this significant change to the court?
That can be a big question, and it's largely fact specific. So some of it can be self-evident. So if it's a financial change, tax returns can do it. You look at, all right, these are the numbers we had at the time that we got divorced or the time that the initial order was entered. Now, instead of a difference of $10,000 a year, there's a differential between the parents of $50,000 a year. So the proportion has changed. Or the child goes to college. That's a self-evident change in circumstance where the direct child support may not go away just because the child moves and lives in a dorm, but there's an adjustment to be made. So anything that supports whatever the factual basis is, you're going to need documentation on.
So let me ask you then, Alex, is court always necessary for these changes and modifications, or can parents reach this agreement on their own?
Court involvement is not always necessary. And I say involvement insofar as, I mean, the court doesn't need to make the decision for you. It is entirely possible for parents to reach agreement with attorneys, through a mediator, between themselves, any number of ways. But if you had an initial support order that was docketed with the court, that was filed with the court, I would definitely recommend submitting the updated order for a judge's signature so that the court is at least tangentially aware that there's been an agreed upon change. Because if somebody comes back, say you made a change and you agreed upon it 5 years ago, and somebody comes to enforce the new agreement, well, what do you have to demonstrate that there was really a new agreement? This is just sort of documenting things to make it easier down the line.
And what happens if in that scenario that now they're in the court and they're trying to agree upon these changes? What happens in the scenario where one parent refuses to cooperate with a change, whether it be, let's say, adjusting a parenting schedule like you were mentioning before, or a support amount? Do you have any examples that you can give us of what happens in those scenarios?
There are kind of two tracks. There's the things that can be decided by motion practice. So if I think child support needs to be recalculated because my ex-spouse is now making a significant amount of money more than they were 2 years ago, I can file a motion to request that the court recalculate support. That's something that the court can generally do without testimony. So we submit documents, they plug the numbers into the formula, and the judge makes a decision. Something more complicated, like a substantial change in the schedule, a change in legal custody, often requires what's called a plenary hearing. So in addition to all of the paper documents, the court's going to need to take testimony. The court's going to need to hear from witnesses. They may require an expert report. It's a lot bigger. It's a much more substantial process, and it takes longer. But it generally is reserved to the more significant issues.
So let me ask you, Alix, we talked about modifying child support. We got spousal support, and then we got custody orders. Are the rules for modifying all three of these, do they differ, or are they consistent across all three?
They're very different. And they're governed by different statutory analysis, too. In addition to having sort of different real life facts around them, they come from different parts of the law. So child support and the custody and parenting time, those are all governed by a standard called the best interest of the child standard. And because you're always looking at the child's needs and what's best for the child, for sort of both of those, that's where you start that focus. Spousal support, alimony is a very different calculation. You're looking at different things. And parents, I say parents, but spouses can agree at the time of a divorce to make their spousal support unchangeable. They can reach that agreement. If you go to trial and the court says this is the alimony amount, that is subject to reconsideration, to a change in circumstance and modification down the line. And an agreement can also leave the door open for modification down the line. But that's only for spousal support. You can't say, I'm waiving child support forever, because child support is not about the parent. Child support is for the child. So you cannot, on behalf of your child, say, no, I don't want child support.
You know, let me ask you, Alix, in your years of experience doing this, what are some common mistakes that people make when asking for a modification and how it could potentially jeopardize their case?
I think a lot of times people go in assuming that because one small thing has changed, everything has changed. It really makes sense to have an attorney look at, all right, if your financial circumstance changed, did it change substantially enough to impact the overall support number? Are there other things that impacted it that's going to offset it? Is it worth the time and money going to the court to seek a recalculation, or are you going to end up spending $5,000 to have a $2 change in your support number, which is going to take you 5 or 6 years to recoup? Is it worth it? People assume that just because there's a change, I immediately have to go do something about it.
So, Alix, piggybacking on that, let's land the plane on this. What advice would you give to someone right now? They're listening to this. They feel stuck with an order that no longer fits their family's reality. What's a piece of advice you would give to them today?
Call an attorney, get a consult, because I'm giving kind of general advice here. I'm giving blanket information about how the court may look at circumstances, but ultimately they're looking at the specific facts of a specific case. So you may have a fact that, I'm not thinking about here that changes the calculation for you, for your circumstance. So call an attorney, have a consult, pull together your documents, and see if it's right for you to pursue something.
Call an attorney. I know one. I'm speaking to one. Alix, thank you for the time and insights today. We truly appreciate it.
Thank you, Mike.
And thank you to everybody out there listening to another episode of For Better or For Court, Family Law in New Jersey. If your custody or support order no longer reflects your family's needs, you heard what Alix just said, and she can help you and your family understand your options and guide you through the process of making a change. Do me a favor today. Visit HeymanFletcherLaw.com to schedule a consultation. And don't forget to like, subscribe, leave us a review and comment. Share this episode with somebody who needs to hear it. As always, I'm Mike Leon. We'll We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.